info. So with that said, we're going to go ahead and move into today's presentation, which is the 2022 case law update. So my name is Kayleigh Long. I'm a member and an attorney here at Hirzel Law. And we are going to talk today about some of the important cases regarding community associations that were decided in 2022. So with that said, we'll take a look at the overview. But before we do so, I will just ask everyone to make sure to put yourself on mute so everyone can make sure that they can hear, that there's clear audio. And of course, if you have any questions about the cases, you can feel free, unmute yourself or type into the chat box, and I will try to answer those as they come up. But, you know, try to make sure that they are limited to the cases that we're discussing today. So the cases that we're going to be talking about today primarily fall into three different groups, and then kind of just a random grouping of cases. And so the first group is going to be bylaw enforcement cases. Next, we're going to talk about attorney fees. Then we have a group of cases about the Fair Housing Act and Persons with Disabilities Civil Rights Act. And then I have what I've called the grab bag of cases. So these are all kind of individual one-off cases that don't really fall into a nice, neat category. So it's going to be construction of restrictive covenants, short-term rentals, slip and falls, and then for those of you who are in condominiums, what is called Section 67. So all of our questions tonight are going to be in kind of question answer quiz format. That's how we're going to discuss the cases. And so our first group of cases up are our bylaw enforcement cases. So the first case, here are the set of facts that you need to know. Michael lives in the Dunder Mifflin subdivision, which requires homeowners to get the association's approval before altering any building, requires alterations to be in conformity and harmonious with the external design of other structures, and only permits 4-foot tall fences that are not solid board or view obstructing. In 2013, Michael placed a solid fence higher than 4 feet in his backyard. In 2018, he installed modern stone siding on his house that looked different from all the other 1,250 homes in the subdivision, including other homes with stone siding, all without the association's approval. So our first question up, so for those of you who are on the game platform, get your phone or your computer ready. The association sues Michael for violating the restrictive covenants. Who wins? And I should also note, for those of you who are participating, correct answers get points. Faster correct answers get more points. So you got to be quick on your answers. So the majority says that the association's going to win. And as you can see, that is correct. So the association, or the Court of Appeals, affirmed the trial court's ruling that the association is going to prevail. Michael's in violation of the restrictions, and he's going to have to, fix both his fence and the modern stone siding. So the homeowners in this particular case raised lots of defenses as to why they shouldn't, why they didn't violate the restrictions, and B, why they shouldn't have to fix anything that they did. So kind of they threw the kitchen sink at everything. They said, hey, we didn't actually know about these restrictions. We didn't have to submit plans to the association if we could finish our project before they could sue us, which was an interesting defense of basically like, if I can get it done before you can sue me, it's all good. They said that their failure to submit plans and get approval was only a technical violation. So kind of a no harm, no foul argument. They say that the association waited too long to sue, particularly about the fence that had been installed back in 2013. And they also said, hey, the restrictions say that I can have stone siding. And they don't say that I can't install my modern stone siding, so this shouldn't be a violation. But like I said, the Court of Appeals disagreed and said that the homeowners did violate these restrictions and they would have to change those alterations. When it came to the stone siding, their main focus was on the restriction that said that the alterations had to be in conformity and harmonious with the external design of all the other structures. And so as you can see from the facts, their modern stone siding looked different than every other house in the subdivision, and including those that also had stone siding. Didn't even look, was not even consistent with those. And then as it related to the fence, the court said the association didn't wait too long to pursue them for their violation regarding the fence. First of all, the homeowners didn't present any evidence that the association knew about the fence going back to 2013. And then secondly, they also said that the association had filed the lawsuit within the statute of limitations. So there was no issue here about waiting too long to pursue enforcement on those. I will note, and there's one kind of common theme for a lot of this year's cases, is a lot of these cases after they got resolved on the Court of Appeals went to the Michigan Supreme Court and asked the Michigan Supreme Court to take up and consider the case. And that's one of these cases too. So something to keep an eye on in 2023 to see if the Michigan Supreme Court is going to pick up the case. And if they do, if they reach a different result. So something to keep a watch out for potentially for the 2023 case law update next year. So here's a quick look at the scoreboard for those of you who are participating on the game platform. And we're now going to move to the second case in the bylaw enforcement. So this is the case that I'm calling Timber. So the facts of this case are Jim lives in the Scranton subdivision, which prohibits buildings from being constructed beyond the timber line along the bay.
I don't know how to get sound.
In 2018, Jim decides to build a home, and after the surveyors stake the layout of the home, Stanley notices that Jim's new home will extend beyond what he considers to be the timber line. Stanley sends Jim 2 notices of the violation, and then files a lawsuit when Jim begins construction of his home. The restrictions, though, do not define what is considered the timber line. Jim says that the timber line extends to all places where there are trees between the house and the bay. Stanley says it only extends to areas where there are large trees or trees of substance. Jim finishes construction of his home while the lawsuit is still pending. So the question that we have here is, who is going to win this in this lawsuit? All right, so the majority says Stanley, and as you can see, that is the correct answer. So this was a very factually intensive case because, like I said, the restrictive covenants did not define what a timber line was. And what actually ended up happening in this case is the trial court judge, he looked at the entirety of the restrictions. He heard testimony from both witnesses and expert witnesses about where the construction of the other houses had been, what is considered to be a timber line. There were competing expert testimony on that. He also went out and actually walked the different properties to try to figure out where the timber line actually was. And based off of everything that the judge had considered and seen himself with his own eyes, he determined,
I have heard.
He determined that the timber line was consistent with Stanley's argument that it wasn't just any place where there were trees, that it had to be where the trees were large and of substance. And in this particular case, the house had been built 70 feet beyond that timber line. And the trial court said, you have to remove that 70 feet portion of your house. So a pretty harsh remedy for those homeowners. But the Court of Appeals said that was the risk that you took when you decided to continue building while the litigation was pending. And so the homeowners who had articulated the large trees or trees of substance argument prevailed, and the homeowners who built even while the lawsuit was pending, unfortunately, going to have to remove at least a decent portion of their house. All right, let me see. I got to move this. All right, so Kayleigh is up in the lead so far. Okay, and then if you've just joined us and if you would like to participate on the online game platform, you can insert the website, put it on your browser, on your phone, and the game pen below, and you'll be able to join us. Last case in our bylaw enforcement section. So the facts of this case are Kevin lives in a subdivision next to Scranton Lake that is governed by the world's best chili association. The subdivision's common areas include a beach park located next to the lake. The subdivision's restrictions prohibit any structures from being installed on the beach park, including anything that may obstruct views of the lake. In 2019, the association decided to replace 2 old swing sets and a play structure in the park with a new swing set and planted a new tree in the park to replace one that had died and another that had become diseased. Kevin complained that the new tree would block his view of the lake and that the new swing set was bigger than the old one. He claimed that both violated the restrictions, so he sued the association. So the question that we have here is the association going to get to keep its new tree and swing set? All right, so a little bit closer here, but the correct answer is yes, the association is going to get to keep its new tree and swing set. So the important facts here, and unfortunately I can't give them all, so I had to hold some of them from you. And so what was important here is that this beach park had 3 swing sets and multiple trees within it for decades. And so the trial court, when they were reviewing the evidence, found that the new swing set that came in, when combined, or when looking at the older swing sets, which was actually smaller than those older swing sets when you combine them together. So he's like, instead of having 2 or 3, now you just have 1, it's smaller. Now you have more of the park for people to use that's not taken up by all these other swing sets. And same with the trees, he's like, hey, there's already been trees here. One has died, one has, disease, had to be removed. So we're just putting one kind of in its place. And so he focused on the fact that these things were already prior existing. They may have been violations of the restrictions, but they were already prior existing and everyone was okay with it. And at least as to those items, those restrictions had been waived. When it came to the view of the lake, the trial court also emphasized here that it was a collective view of the lake. So it wasn't just one individual from their one lot. Is that going to be obstructed? But is the community view of the lake going to be obstructed or impeded? And in that case, the trial court said, no, it's not an impediment or obstruction of the entire collective view of the lake. So those are not going to be restrictions either. So we'll have some takeaways on this case and I'll follow up on some questions that have come in, but we'll do a quick check on our scoreboard. All right, we have someone new moving into first place. So the takeaways for this case. So especially for the first two cases for those homeowners, a big takeaway is ask for permission, not forgiveness. Courts are really going to enforce restrictions as written. And it is possible that, you know, you build a house 70 feet beyond a timber line and you're going to have to remove that portion of your house. For both homeowners and associations, the second big takeaway is make sure you follow the approval process in your restrictive covenants. So if you're a homeowner, if you need to get approval for something, you need to get approval for it. If you're an association and you have an obligation to review and either approve or disapprove items within a certain time frame, you need to make sure you do that as well. And as the last case shows, there might be instances in which restrictive covenants are not strictly enforced. However, those are very highly fact-specific scenarios and should be approached with caution. So those are the big takeaways from the three cases that we talked about today. So some questions. So from the earlier question of question 1 regarding the fence and the stone siding, what was the statute of limitations? And so under Michigan law, you have two different statutes of limitations that might be applicable here. The first is breach of contract actions are 6 years statute of limitations. Breach of a covenant, so something in a deed, is a 10-year statute of limitation. And then there was also a question here about, you know, that case is pending on appeal, so who really won? Well, so far, it is the association who won, and the Michigan Supreme Court ultimately will decide whether or not they're going to hear the case. They don't have to hear it. So if they decide, I'm not going to hear the case, then the associations or the Court of Appeals decision saying, yep, association wins, will stand. And that will be the end of that. So just something we have to keep an eye on to see if the Michigan Supreme Court decides to take it up or not. So we're going to move into our second group of cases. And this is just going to be one question, two cases kind of combined, attorney fees, always a favorite topic for everybody in a condominium or homeowners association. So the facts of this case are Dwight lives in the Bears Beats Battlestar Galactica Association, which contains numerous landscaping restrictions and requires prior approval for new structures. Dwight decides that he does not have to comply with any of these, and he violates several of them continually. The association sues Dwight for his various violations, and while the parties initially were willing to reach a settlement on many of the violations, they could not agree on an amount of attorney fees that Dwight would pay to the association, so the case does not settle. The association ends up losing in the trial court, but that decision gets reversed on appeal and gets remanded back to the trial court to determine how much in attorney fees the association is going to get. So the association goes to the trial court, asks for its attorney fees that it had incurred in the trial court, on appeal, and in the proceedings after the appeal. The trial court, however, only grants the association a limited award of fees that had incurred up to, but not including the appeal or any of the proceedings after the appeal. So the association appeals again, seeking an award of attorney fees from all the proceedings. So, question here is the association going to be successful on appeal for the second time? An even split. I like it. So as you can see, the answer here was yes. The association is going to be successful on appeal a second time. I'm sure it was very frustrating for this association to keep going to the Court of Appeals to ask for different forms of relief. So the majority of the facts of this question come from the first case on the slide, Copperfield Villas Association versus Tour. And so in this case, the association's document stated that it was entitled to attorney fees and costs incurred in any proceeding arising because of an alleged default by a co-owner. And the issue here, the trial court basically was like, well, you basically had almost reached a settlement agreement. You just held out for attorney fees. So I'm just going to cut your attorney fees to that point. You didn't have to go through all this other stuff. So I'm not going to give you attorney fees for you continuing to press on in the trial court, then going up on appeal, having my decision overturned, and then coming back and asking for attorney fees. And so when the association goes up to the Court of Appeals again, the Court of Appeals says, the language in the document says that the association's entitled to recover attorney fees and costs for all the proceedings, not just some of them. And so the Court of Appeals, has to send it back to the trial court again for the trial court to determine how much an attorney fees and costs the association is going to get for both the trial court litigation, the appeal, the proceedings after the appeal, and then likely now the second appeal as well. And the Court of Appeals, in response to the trial court, which had basically said, hey, you had basically reached a settlement agreement. You didn't need to incur all these additional attorney fees and costs. The Court of Appeals said that the association didn't have to accept a bad settlement agreement. It was entitled to its attorney fees and costs. And if it didn't like the terms and conditions that were on the table, it wasn't obligated to accept what had been offered. The second case that I mentioned is loosely connected to this case as well. That involves a collection lawsuit that allowed the association to recover both unpaid assessments, interest, late fees, and attorney fees. And in that particular case, when it came to the attorney fees, the trial court just said, you're only going to get $500. I think that this was a really easy case. You're just going to get $500, regardless of how much attorney fees and costs you actually incurred. So that went up on appeal, and the Court of Appeals reversed that decision as well and said, trial court, there are specific Michigan cases that have all these different requirements and considerations that you have to go through when you're determining how much an attorney fees and costs you're going to award. You didn't go through any of that analysis. You just gave an arbitrary number. And so we're going to send it back to you, and you're going to have to do your homework. You're going to have to go through all those considerations. So with that said, we'll take a quick look at our scoreboard, and we'll take a look at we have somebody with 3 correct answers in a row. Moving up, nice. So our takeaways when it comes to attorney fees. So both of these trial courts really did not like attorney fee provisions. And so these cases stress that attorney fee recovery provisions do need to be enforced and applied by the trial courts. If it says the association's entitled to them, they're entitled to them. They cannot arbitrarily come up with a number for an attorney fee award. There is considerations that Michigan law outlines that they have to go through. But one consideration for associations is, while the trial court has to do its homework when coming up with an attorney fee award, it does not necessarily mean that the association is entitled to all of the attorney fees that incurred in litigation. Trial court is going to award what it considers to be reasonable. And so it could be 80% of your attorney fees, could be 90%, could be 100%. But it's not necessarily a guarantee of 100%. The trial court thinks that a smaller amount is reasonable. All right. So moving briefly, so there's really one case in this section, and then just kind of an update on how another case affected one of these other statutes. So the Fair Housing Act and Persons with Disabilities Civil Rights Act. So our first case comes from the Fair Housing Act, and this is the case of the patio grills. So Phyllis lives in Vance Acres, a 2-building condominium complex. Vance Acres has an outdoor grilling area with 2 gas grills, and residents are prohibited from keeping or using grills on their patios and balconies. Phyllis has arthritis and has difficulty walking without a cane, so she requests a reasonable accommodation under the Fair Housing Act from the association to use a gas grill on her ground floor patio, and she includes a letter from her doctor showing that she's disabled. The association denies her request and she sues. So the question here is Phyllis going to get her own personal patio grill? All right. Ooh, also kind of evenly split, but actually here the answer is no. So going back to the facts of the case. So under the Fair Housing Act, accommodations have to be reasonable and necessary to provide a disabled person with an equal opportunity to use and enjoy a dwelling, just the same as a non-disabled person could. And so in this particular case, the homeowner's preferred accommodation, which was to keep a gas grill on her patio, was not necessary to afford her an equal opportunity to use and enjoy her dwelling. And again, I withheld some facts from you in this case. The association actually offered to either have an employee bring her a shopping cart or carry her food and utensils out to the gas grill to help her actually get to the grill and to be able to use it. But she rejected that alternative accommodation. Another factor that was dispositive in this case was the association had presented evidence that its insurance carrier had said that if there was actually a prohibition on grills with open flames on these patios, because their insurance carrier said, if you don't have this, we're not going to issue you any insurance coverage. And so the court here also said, the fact that they might lose their insurance coverage if they permit this as an accommodation means that it's not reasonable. And so in this case, the homeowner doesn't get her own personal patio grill. One thing to note about this case, this is our one federal case. This case actually came out of the federal courts in Ohio, but it was decided by the Sixth Circuit Court of Appeals. So it is binding on Michigan federal district courts. So if you end up in the Eastern District or Western District of Michigan, this case is going to be binding on those particular courts. So I believe, oh, here we go. We're going to have an update on our scoreboard. All right, moving around in the top 2 or 3. All right, so no questions here. This is just an update. So Michigan has a state law called the Persons with Disabilities Civil Rights Act. In some ways, it is similar to the Federal Fair Housing Act. It is slightly different, does offer some more broader protections to different classes of people. But if you have been here for some of my other case law updates in previous years, you maybe remember the case Estate of Romig by Kuhlman, which had held that in a published opinion that a co-owner who already lived in the condominium could not bring a reasonable modification claim against their condominium association under the Persons with Disabilities Civil Rights Act because it occurred after the real estate transaction, i.e. after the co-owner had already bought their unit, after that had already been completed. So they basically said this co-owner has been living here for several years already. They purchased their unit, long ago. Their potential remedy here is going to be under the Fair Housing Act, not the Persons with Disabilities Civil Rights Act, because the discrimination has to be tied to an actual real estate transaction, and no real estate transaction here occurred. In 2022, this past year, the Michigan Supreme Court actually vacated that opinion. The case was later dismissed against the association, but on different grounds. And so now that published opinion saying condo associations, can't bring a cause of action against them for accommodation and modification discrimination claims. If it's after the real estate transaction has already occurred, that opinion now is no longer out there. And so now, there's a case to be made that homeowners and condominium associations may now be still liable under this act with that opinion now off the table. So some takeaways from these two cases are, first, homeowners and occupants who have disabilities, they are entitled to reasonable and necessary modifications and accommodations, but that may not always be their preferred modification or accommodation. And then, like I just said, condominium and homeowners associations may again be liable for reasonable accommodation and modification discrimination claims involving homeowners and occupants who already reside in their communities under the Persons with Disabilities Civil Rights Act again. But I include a ... here because, it is very possible and it's very likely that another case kind of similar to that, alleging similar cause of action, may come up before the Court of Appeals again. And they may reach, the same conclusion that they did in this previous case. But it's just something that we're going to have to see, and that time will tell. All right, so we're going to move to what I call just the grab bag of cases. So they kind of stand on their own. They don't fit into a nice, neat category with any other cases. So first case is construction of covenants. So here we have Kelly, who lives in a high fashion subdivision, which is subject to the following restriction. No building or other structure shall be erected or altered or permitted on any lot other than one single family dwelling house with attached garage, except swimming pool, tennis court, badminton court, walls, or fences, and such other auxiliary construction. Kelly built a storage barn, and the association demanded that she remove it because it violated the above restriction. She refused, so the association sued to have her remove it. So the question here is Kelly going to have to remove her storage barn? Oh my gosh, so fast. So everyone here said yes, but the answer is actually no. So let's talk about why that is. So there actually was, this is one of the rare or one of the few cases from the Court of Appeals that you see where there was not a concurrence or agreement among all three judges. Two judges wrote the majority, and that was the result in this case. So here, the Court of Appeals said, nope, this homeowner is not going to have to remove her storage barn. So the homeowner in the trial court said, this phrase, auxiliary construction, is ambiguous, and so it's not enforceable. Like, who is supposed to know what auxiliary construction is? And so that's just unenforceable. I get to keep my barn. The Court of Appeals disagreed with the homeowner on that and said, no, that phrase is unambiguous. We can interpret it and it can be enforced, but your storage barn is auxiliary construction. So they used dictionary definitions, pulled out a dictionary, and they define auxiliary construction as a structure built to function in a subsidiary capacity or to aid or support a single family residence. And so they said, based off of that definition, your storage barn fits into that definition, so you get to keep your storage barn. So like I said, it was a partial concurrence and a partial dissent. The one judge here, the third judge, said, actually, he did not agree with their definition of auxiliary construction. He said that it had to be similar to the other structures that were mentioned around the term. So it had to be similar to a swimming pool, a tennis court, a badminton court, walls, or fences. And because the storage barn wasn't similar to those things, it could not be considered auxiliary construction. However, he still decided that she could keep her barn because the association had not enforced this restriction against other structures that also violated the restriction. So the association had allowed other people to build other things that would not have qualified as auxiliary construction, would have violated this restriction. He said, hey, you waived that restriction. You didn't enforce it against anyone else. You're not going to be able to enforce it against her. So an interesting case about how different judges might decide to interpret in different ways the same particular restrictive covenant, and again raising the issue for associations about the potential argument of waiver and making sure if you've got a restriction that you enforce it and you enforce it uniformly across your community. Let's see, there we go. Take a look. Oh yeah, that's right. So we're gonna hold at our scoreboard, no movement on the scoreboard for now. So the next case up is everyone's favorite topic, short-term rentals. So here, Andy is the owner of a short-term vacation rental company, Nard Dog Enterprises. For those of you who have not caught on, all of my references are coming from the TV show The Office. I was watching The Office while I was making this presentation. This is where my inspiration came from. Regardless, he buys a house in the Big Red subdivision to add to the Nard Dog short-term vacation rental portfolio. The subdivision has restrictions that state that the lots can only be used as single-family private residences, and no business of any sort other than a home office may be conducted from or on a lot. The restrictions also state that leasing is permitted, but homeowners are liable for the conduct of their tenants. Nard Dog began short-term renting the property, and the association sues them, arguing that the short-term rentals are prohibited by the restrictions. So the question coming out of this case is, who's going to win? All right, so a nice even split again here, but the two people who answered association are correct. So this case deals with, so this case involved all three of those restrictions. And the Court of Appeals said that you had to read all three of those restrictions together. And so the person who wanted, or the company that was wanting to engage in short-term rentals, focused in on the leasing is permitted and said, it says leasing's permitted, so I get to short-term rent. And the association said, yes, it says that, but it also says that it can only be used for single-family private residences. And it also says that you can't conduct a business from or on the lot. So you have to read all three together. And when you read all three together, that means that you can engage in leasing, but if it violates those other restrictions, you can't engage in that activity. And the Court of Appeals agreed with that approach of having to read all three restrictions together. And importantly, the Michigan Court of Appeals has several cases out regarding short-term rentals and has said that residential restrictions, such as single-family private residence restrictions that we have here, means that there has to be some permanence to the presence on the property. And short-term rentals, these people just don't have a long enough presence on the property. They don't leave anything behind. They don't have a right to come and go from the property at any time. They have a limited right to occupy the property. They're typically not there very long, maybe just a few days, maybe a week. And that's not going to be enough to comply with a single-family private residence. And when it comes to business and commercial restrictions, there's at least one, and actually recently this year, so it's not in the case law update because it just squeezed into 2023. There's now two published opinions out of the Court of Appeals which say that short-term rentals are a business and commercial use of property. And so because of that, in this case, the Michigan Court of Appeals said short-term rentals were prohibited by these restrictions, notwithstanding the fact that leasing was generally permitted. So only activity, only leasing that complied with the single family private residence and the no business restriction would be permitted. So we'll take a quick look at our scoreboard. All right, we have Christy who's pulling away just slightly. I believe we have, let me see, we have two more questions. So for those of you who are still competing, make sure you have your phones ready so you can get your answers in there quickly. So slip and falls, another big one that I think a lot of associations are going to be interested in. Ryan lives in Dunder Mifflin Infinity Condominium. His association is responsible for maintaining the sidewalks and parking lot. On one winter day, he was taking his garbage out to the dumpster, but he fell on the snow and ice that was covering the parking lot. He sued the association for injuries he suffered when he fell in the parking lot. So the question here is the association going to be liable for Ryan's injuries? Ooh, quick answers here, and the no's actually do have it. So let's go back and take a look. So the decision in this case was primarily based off of a case of similar facts that came out several years ago, I believe in about 2015. And it was a really interesting argument and decision from the Court of Appeals. So in this particular, or these slip and fall cases are what are typically referred to as premise liability cases. So it's about condition of the property and whether the landowner, the person who owned the property, cared for it in a particular way that ended up harming, somebody else who came onto the property. And so premises liability claims, there are different standards of care that you owe to different people who enter your property. So if you have a trespasser who enters onto your property, you have a pretty low standard of care because that person's not supposed to be on your property anyway. If you have a licensee or an invitee, so people that you are actually inviting onto your property to do business or something else like that, you have different higher standards of care for those individuals because you're welcoming them onto your property. They're going to be on there. You're inviting them on. However, the case that was decided several years ago said that this is a condominium and this is a co-owner, and they all have an ownership interest in the common area. And premises liability claims are against the landowners who own the land. And so essentially here, the co-owner is suing themselves for a premises liability claim. And so the Court of Appeals said, co-owners can't bring these premises liability claims against their associations because the co-owners themselves are the actual owners of the land. So basically they said that, you're not entering the land of another, you're entering actual land that you own yourself. And so the association is not going to be liable to those co-owners based on premises liability claims. One thing that this court noted is that this co-owner did not actually also bring a breach of contract claim. So it's not to say that it's a necessarily get out of jail free card for associations. So you still need to make sure that you're maintaining your common areas. But at least when it comes to premises liability claims, the Court of Appeals has said that associations are not going to be liable to their co-owners. There is a note here. I actually meant to mention this for some of the cases before. So this is one of the cases that's pending on application for leave to appeal with the Michigan Supreme Court. So this is a case that we're going to have to see if the Michigan Supreme Court wants to take another look at it and render a different decision. So again, keep an eye out, blog articles, in case or if a different decision comes out this year or next year's case law update. The Michigan Supreme Court may decide to change the law in this area, but as of right now, that's where it stands. And also too, I had meant to mention this short-term rental case as well. That's also pending on application for leave to appeal with the Michigan Supreme Court. So if the Michigan Supreme Court decides to hear it, a different or the same result may end up happening, but just to keep your eyes out for those cases, since the Michigan Supreme Court has been asked to at least possibly take a look at it. All right, so let's go back to our scoreboard. Okay, got some people moving up, and we do have one last question left. So for those of you who are competing, would like to get the podium seats, the top three. So if you'd like to get in the top three, this is your last chance. So this is going to be for condominium associations. So sorry to all of you homeowners associations out there, but this is going to be specific because this comes from the Michigan Condominium Act called Section 67. So in 2004, The Scranton Park condominium was created with a goal to build 50 townhouse-style units, but 45 of those units were designated as need not be built. Those 45 units were never built, but in 2009, they were sold to a bank who then sold them to Threat Level Midnight Enterprises. In 2018, the 45 units still had not been built, so the association sued Threat Level Midnight, claiming that the 45 units had automatically become general common element land under Section 67 of the Condominium Act, and therefore Threat Level Midnight no longer had a right to construct or build the units. So the question in this case, last question, is who wins? All right, so a little bit of a split, but the association here is going to win. And before I forget, this is yet another case that is pending on application for leave to appeal with the Michigan Supreme Court. So they haven't decided whether they're going to hear it or not, but just to be mindful of, it is possible that the Michigan Supreme Court may decide to hear it, and if they do, may decide to reach a different result. So Section 67 under the Michigan Condominium Act is a fun statute. So in 2002, or I should say, I believe back in 2001, Michigan legislature became concerned about the fact that you had Michigan condominium projects that were never getting fully built out. They would just kind of sit around for years and years and years with all these unbuilt units. So they decided, hey, we're going to put a time limit on when these developers have to finish constructing their condominiums. And if they don't finish constructing their condominium projects within a certain amount of time, any of those units that were labeled as need not be built, that are not built at the end of that time frame, are just automatically going to become general common element land in the association. Because we want to close out these projects. We want them to be done and over with, so associations know how many units they have, how many co-owners they have, they can make budgets, things of that sort. So in 2002, the statute said that 10 years after construction of the condominium had started, the developer either had to build all his need not be built units or remove the land from the condominium. And if they hadn't done it within that 10-year time frame, they would automatically become general common element land within the condominium. Nothing the association needed to do to make that happen. It just happened as a matter of law. Well, some issues began arising because in 2016, the Michigan legislature said, hey, instead of this just automatically becoming general common element lands, we want there to be some sort of notice and vote and process. And so they ended up changing the law to say, instead of automatically becoming general common element lands, the co-owners had to vote as to whether or not they wanted it to become general common element lands. If a majority of the co-owners decided to move forward with that, they send a notice to the developer and say, hey, you haven't built these units. We'd like for it to become general common element lands. You have 60 days to either, designate these as must be built, withdraw them from the land, or they're going to become general common element lands. Your developer has their time to make their decision. And then only if the developer decides not to do anything with those units does it become general common element land. So a much different process, not automatic. Well, there was litigation, of course, that resulted after that of, well, what do you do for associations where the 10-year time period had expired before 2016? Is that land still just automatically general common element land? Or do those condominium projects need to go through the co-owner vote developer notice process? So back in 2019, the Michigan Court of Appeals said, if they've already become general common element lands under the prior versions of the statute before 2016, They're general common element lands. They don't go through the notice process. They don't go through the vote process. That's it. The developer doesn't get to construct those units. So what this case involved here was that the land or those unbuilt units had been sold to somebody who claims that they were not the developer. And so they said under section 67, hey, that only applies to the developer. And if I am not the developer and I own these unbuilt, need not be built units, I still get to construct them. The statute doesn't apply to me. And the Court of Appeals in this case said, nope, it applies to you as well. And so you also do not have a right to construct these units. And so that's general common element land, and you don't get to construct the units moving forward. So like I said, though, this case is pending on appeal with the Supreme Court, Michigan Supreme Court. So we will see if the Michigan Supreme Court decides to pick it up and reach a different result. But that is where we stand, at least as of today, February 9th, 2023. So let's do a final. Okay, so this is the thank you, we're done. Any questions? But I will show the scoreboard and then I will open it up to questions. So that way, if you reach the top of the podium, you can have your little moments. All right, Coley, third place. Second place, Penny. And then our winner, 6 out of 9. Nice job. Christy, there is no prize for this, but if you would like to take a photo of it, you can certainly take a photo of it, have your bragging rights. Feel free, do what you want with that. I'll leave it up for a little bit. So I will take a look at the chat to see if there are questions about the cases that I might be able to answer here. If you do have some questions, you can go ahead and unmute yourself. Again, should be about the cases that we discussed today. And I can see if we can answer those for you because we do have some time left.
I'm trying to raise my hand.
Yes.
But where is it?
Oh, well, I hear you.
Oh, hi, I'm sorry. This is Karen Lloyd. So about this case 67.
Yes.
How does that apply to what we've been discussing in that the developer has written into the master deed the right to come back and develop?
So this is only for unbuilt units. So this is only for when the developer creates the project. They're supposed to say, this is how many units I'm going to build. This many are must be built. This many are need not be built. So it's only in reference to building out the initial condominium projects.
Okay. Okay. Thank you.
Yeah.
I had a question, Kayleigh.
Yes.
Early on, you were talking about enforcement of bylaws.
Mm-hmm.
Is it important for us to document our rationale on these cases so that if we are challenged on one, we can show that we have uniformly been enforcing the bylaws?
So it is helpful if you can show, so if you have multiple violations of the same restriction, to show that you took consistent action and uniform enforcement against all of those. So yeah, I would definitely recommend, have a documented history of, these lots had these violations. We sent them these violation notices. This one got resolved on this date. This one didn't get resolved. And that's why, we're at this particular point, things of that sort. Because it is, helpful if somebody says, you've never enforced it against that. Look at, XYZ lots over here. If you can show that you either did enforce it or you're in the process of enforcing it, that can be helpful.
Thank you.
Yep. Anybody else?
There isn't. I have a slip and fall question.
All right, go ahead.
Does the slip and fall, excuse me, relate also apply to limited common elements. And if we have a snow removal contract that excludes salting the walkway, but includes clearing the walkway, are we protected?
So this is only for premises, or those cases were only for premises liability claims. So they would not involve any contractual obligations that the association may have. So those, basically a premises liability claim is a tort claim, which is separate and different from a contract claim. So only as it relates to tort premises liability claims, at least what the Court of Appeals has said is that if the co-owner has an ownership interest in the land, then it's not a land of somebody else, it is your own land. So there's not going to be a premises liability claim there against your association. So, you know, with a limited common element, typically the co-owners are going to have some sort of ownership interest in that limited common element as well. So it is possible that the bar on a premises liability claim would apply to that as well. But it would probably depend on, you know, was a limited common element assigned to a particular person or not.
Another slip and fall.
Go ahead, sir.
Another slip and fall question. We have, our HOA maintains the roads, we plow and sand them or whatever, and people actively use them to walk. But people come into the HOA from neighboring areas and walk there also because the roads are in fairly good shape. Are we leaving ourselves open to liability by allowing those people to come and walk their dogs and walk around there?
So under premises liability claims, there are different standards of care for different people. So if they're trespassers, if they don't have a legal right to use that land, there's a pretty low standard of care for them. I don't know those standards of care like right off the top of my head, but it's the lowest standard of care, as you can imagine, because it's somebody who's not supposed to be on the property. So it typically involves, you know, you don't have to warn them about any hidden dangers, things of that sort. And when it comes to snow and ice, except for black ice, but when it comes to snow and ice, you also have the issue of the open and obvious danger of, you can see the snow, and again, unless it's black ice, you can probably see the ice. And so is it something that you could have avoided? But just to say, there are different levels of standard of care. So determining, depending on whether or not they have the right to come in and walk through the property is going to dictate the level of standard of care you have to give to them.
Does that kind of go with renters then that you have in the association?
So that would be for, I believe, the premises liability claim. I'm trying to think. I believe that those are going to apply to anyone who's going to be coming into the condominium. So you should be able to anticipate, if you allow renting of your units in the condominium, then you should be able to anticipate that you're going to have renters and tenants in your condominium as well. But I don't know that those two premises liability dealt with renters or tenants. They may have just dealt with actual co-owners.
Hi, this is Mary. I got a question on the reasonable and necessary. I put it in the chat thing there. I don't know whether you saw it or not. We have a family in our condo association that has a young disabled child, and it has caused quite a stir. The child is young. I think he's like 7 or 8. He's autistic. And he doesn't understand safety elements. His parents allow him to play in the front yard. He continually runs right out to the front road, almost to the road. Most times he stops, apparently. I've witnessed this myself. And we have neighbors that are very, very, very upset about this because of the safety element, as are we on the board concerned about it. We have talked to them numerous times, asking them to please, you know, keep this young child, you know, back away from the road, please, as a safety element. You know, you may trust that he's going to stop. The person's driving down the road may not know that, and they may panic and an accident could ensue. They have asked us to put some sort of a temporary fence or something out in their grass area, which is all common area and fences aren't allowed. We have said, come to us with a suggestion of what you'd like to do, and we'll see if we can, work with you. They have also allowed the little boy to sit on a power box that happens to be right on the corner of their property. We had the power company come out and put stickers on the box stating that it's not safe for anybody to be on or near this power box. That hasn't stopped them either, and the little boy is still sat there. I guess we're concerned on this reasonable and necessary. We don't think any type of fence or anything like that is reasonable and necessary for the livelihood of this little boy. However, we're having issues with the parents trying to get them to comply with this. Any suggestions, ideas?
So I would recommend that you follow up with us one-on-one, because this is a very particular case with very particular facts. And so, we certainly would want to look into it a little bit more and see if you might need to give some sort of accommodation or what that might look like. Particularly because it does sound like it may be a Fair Housing Act claim. And those, can be kind of tricky and sticky. And we would want to try to help you, try to avoid a possible discrimination claim.
Okay. Yeah. I mean, he could play in the backyard. They choose not to do that. They choose to put him in the front yard, and, it's just causing issues.
Sure.
I can't tell you how many numerous complaints I have dealt with on this.
Sure. Yeah.
Way
I
too
understand.
many.
Yeah. Feel free. If you want us to kind of take a deeper dive into it, we can take a look at it.
Who should we contact? I mean, I'm in contact with you guys all the time anyway, but I don't know
Yeah. Who do
who to
you
contact on this.
who do you normally communicate with?
Oh, let's see. I'm dealing with Chantel on one issue. I'm dealing with I think Michael on another one, and I'm dealing with Kevin on another one.
Oh,
So
okay. Then you can send it to any of them. All of
Okay.
us will, whoever has the ability to, take care of it at that particular time, you can just send it to someone. We'll make sure it gets assigned to somebody.
okay.
Yeah.
All right. It's particularly if they threaten to like sue us or whatever.
Sure. Yeah.
Hopefully that won't happen.
Yeah. Yeah. We would want to avoid that if we could.
All right. Thank you.
Yeah.
I have a quick question about short-term rentals.
Yes.
So in the bylaws, it says that a lease means any occupancy agreement, whether or not in writing or for rent or other consideration, where the unit is not occupied by the co-owner or an immediate family member. Does that mean, do you interpret that as meaning friends of co-owners cannot use the condo for a weekend or a week without the co-owner being there?
That could be the case, but I would want to look at the language kind of surrounding that as well, because in isolation, it sounds like it could be, but there might be language around it that might provide a different perspective.
Okay, because it's part of it, it's because we have a 10%.
Sure.
And I don't know whether a friend coming to stay with paying no fee means it is under that regulation of the 10%.
Yeah, so that would be something similar to Mary. If you want us to take a specific look at the language in your documents and give you an opinion on that, we certainly could.
Okay, all right, thanks.
Mm-hmm. Any other questions on today's cases? All right, hearing.
I had one question, Kayleigh, and it was on the statute of limitations.
Yes. Mm-hmm.
And although you talked about it in relations to violations, what's the statute of limitation on collections?
So it is going to be a similar one as well. So if you look at it from a breach of contract standpoint, it would be a 6-year statute of limitations. So I'm guessing you're talking about unpaid assessments is what you're.
It was actually a special assessment. So the association covered the cost of a homeowner's garage roof, and they haven't paid the association back.
Yes, so but that's all coming out of the governing document. So it's some sort of assessment that has not been paid. Yes. So breach of contract, 6-year statute of limitations. And then there's also specific language for, kind of breach of a covenant and a deed. And so many times associations might argue, you know, if the deed references that it's subject to, you know, restrictions within condominium documents, or if there's a homeowners association, you might be able to make an argument that you get the 10-year statute of limitations instead of just the 6-year statute of limitations.
Okay, thank you.
Any-
Can I get clarification on something, Kayleigh,
Sure.
about the statute of limitations?
Yep.
In a previous, and maybe I'm just confusing it, but in a previous seminar, we learned that the bylaws stand, and if a previous board did not follow the bylaws, that did not set a precedent for subsequent boards. And
Yeah.
therefore there was no statute. Can you clarify that, please?
So that's actually waiver. So that's not in reference to a statute of limitations.
Okay,
That's gonna be in reference to the waiver defense, which has kind of popped up in some of the cases tonight.
okay,
You know, to say, hey, you've never enforced this violation against somebody else before, or this other person, why are you going to get to enforce it against me, or, you know, at me at this particular time? And if your documents have an anti-waiver provision, you know, you can try to rely on that argument of, well, this specifically says that even if we fail to enforce our documents, we're not waiving those and we have the right to later enforce them. So not a statute of limitations, more so in response to a potential waiver defense from a homeowner.
okay, thank you.
Yep. Yeah, and I believe the case that was probably discussed in that one was the Fox Point Association case.
Yes.
Yeah, so that was involving a co-owner who said that the unit that she purchased was already in violation. And so the association had waived its right to enforce the restriction against her because it hadn't enforced it against her seller. And the Court of Appeals said there's this anti-waiver provision here, so you're just as responsible for it as your seller would have been.
Thank you.
Does that waiver restriction hold up pretty well? We have one in our bylaws of the waiver restriction. That's why does it hold up pretty good?
So from the cases that we've seen so far, so it did in Fox Point Association versus Royale, that was a 2019 case, unpublished. So it's just persuasive authority. Also, I believe that same year, it's a Dearborn West Village case versus Mackey, I believe is what it was called, 2018 or 2019 case. That dealt with a situation where the association had not enforced its rental restrictions in previous years, and then they had gotten a new board and they decided, okay, we're going to enforce what we have. And they had an anti-waiver provision, and the Court of Appeals upheld that and said, you know, there's not going to be a waiver defense here. So, but again, also an unpublished opinion. What is notable is at least the waiver cases that have come up tonight, there's not a mention as to whether or not there was an anti-waiver provision. So, you know, for example, that auxiliary construction storage barn case, you know, the facts didn't say whether or not there was an anti-waiver provision. And maybe if there had been, maybe it would have been a different result. Anybody else? All right, well, seeing no other questions, we'll go ahead and wrap up the case law update. So I will note that most of the cases that we discussed tonight, we did have little blurbs about them on our blog website, so mycondolaw.com. And so when these cases come out and we think that they're important, we do try to give you little updates throughout the year. So you don't just have to wait for me to give you the update in January, February each year. But we do like to do this roundup just to give you a good deep dive into what the cases were from the past year to be mindful of. And like I said, we have lots of cases that people have asked the Michigan Supreme Court to consider. So maybe some of these cases will be coming back next year. So with that, everyone have a good night. And again, this will actually be on YouTube. So if you want to hear me again, go through all these cases,